Okay, can everyone hear me? Thumbs up if you can. Excellent. Good evening to those in Europe and good morning to anyone joining us in the States. And hello to anyone listening to us at a later date on a podcast. This is a live Zoom webinar that is being broadcast on Twitter Spaces as well. Welcome to the Platform for Peace and Humanities webinar, revisiting the Kosovo Specialist Chambers, Reflections and Outlook. My name is Luke James. I'm the director of the platform's Southeast Europe and Black Sea region program. Today, we're going to be talking about the Kosovo Specialist Chambers, often described as a hybrid court. It is integrated into Kosovo's domestic court system, but it is internationally staffed and physically located in the Netherlands. It was set up to try crimes allegedly committed during and in the immediate aftermath of the Kosovo War. Kosovo was, and probably still is, considered by some to lack the capacity and political will to investigate alleged war crimes committed by the Kosovo Liberation Army, the KLA. And it is within this mandate, crimes against humanity, war crimes and other crimes under Kosovo law, that the Kosovo Specialist Chambers operates in. Kosovo incorporated the Chambers and the Specialist Prosecutor's Office into its constitution in 2015. The first indictments were in 2020. And there have been no convictions to date. Many describe Kosovo as being pressured by the international community, particularly the EU and the US, to agree to establish the court. Indeed, the current Prime Minister, Abit, has recently described the court as not transparent and that it is a fait accompli, casting aspersions on the court's impartiality, neutrality, and competence. The court itself has already had an impact at the highest level of Kosovar politics. In June 2020, former President Hashim Thaçi signaled a willingness to enter negotiations with Serbia's President Vučić. The meeting was facilitated by the Trump administration, and some speculated a recognition agreement was on the table. However, President Hashim Thaçi later that year was indicted at the court, forcing his resignation from the office. The negotiations then broke down. The indictment alleges that Hashim Thaçi and others are individually criminally responsible for the crimes committed in the context of the Kosovo conflict. The alleged crimes committed were part of a widespread and systematic attack against persons suspected of being opposed to the KLA. Nearly 2 years on from President Thaçi's arrest, reconciliation between Kosovars and Serbians remain at a low point. Last summer, Serbia deployed fighter jets over the border as a show of force following an intensifying dispute over reciprocity of license plate recognition. The tensions necessitated NATO to redeploy some of its troops to the border zone. Today, when you cross the border by car, the border guards still give you a sticker to cover your Serbian number plate emblem with a Kosovar one. Dialogue between Kosovar Prime Minister Kurti and Serb President Vučić remain extremely difficult. During the Serbian election earlier this spring, Kosovar's parliament, led by Mr. Kurti, had decreed that Kosovo would no longer allow Serbs living in Kosovo to vote in Serbian elections in Kosovo. The international community swiftly voiced concerns and disappointment over Kosovo's decision. Every 6 months, the UN Security Council holds a meeting on Kosovo, and the tensions at the diplomatic level are palpable. The Serbian Minister of Foreign Affairs recently described the KLA, and I quote, as the real butchers of the Balkans. So what? What does this mean? Well, to help us understand the context and the pressures within the court operates, as well as the developments at the court itself, we have 3 incredible guests to join us today. Abit Hoxha. Abit is a lecturer of journalism and researcher at the University of Agder in Norway. After the Kosovo War, he worked in the Office for Missing Persons for 3 years and has worked with communities on both sides under the right to return. Abit, we're really glad to have you here today. Xhorxhina Bami. Xhorxhina is the on-the-ground correspondent for Balkan Insight in Kosovo. She often reports on developments at the court, and I see, Xhorxhina, you've been busy today reporting on the tensions actually down south, not far from the border in North Macedonia. Xhorxhina, thank you for joining us. And Gregory Kehoe. Gregory Kehoe is the defense lawyer and counsel for former President Hashim Thaçi. If you watch one of the most recent status conference videos from the court, you'll notice that Gregory is currently advocating for a more streamlined process at the court. And we'll certainly come back to that. Mr. Kehoe, thank you for joining us. The format of this webinar will be that each speaker will have 6 to 8 minutes. Then there will be an opportunity for each participant that has spoken to respond to your fellow panelists, and then we'll go to a Q&A in the audience. So, turning first to Abit. Abit, we spoke the other day about transitional justice and this concept that you've been deeply involved in, transitional journalism. You know, the importance of journalism in shaping and crafting the narrative of what justice looks like. I'm wondering if you could speak a little bit about that in the Kosovo context, and what is the public perception of the court, perhaps a deeper dive into the history and negotiations that led to the court.
Yes, Luke, thanks for having me. So my background goes back into working in the field in Kosovo for about 12 years, working with Missing Persons Office, working with communities on both sides to try to return Serbs to Kosovo in the aftermath of war in Kosovo. But also, I'm a survivor of war in Kosovo. I was during the war in Kosovo, and I was in 2 particular events in Kosovo when people have been shot. In Izbica, namely, where about 130 people have been killed. I was about 200 meters away when that happened. And I'm originally from a small village called Rezala, where tens of people have been killed and we're still looking for the bodies. So my motivation for working with the Office on Missing Persons and Forensics in the aftermath of war was also personal. But to start with the subject of what we're discussing today, the allegations for the Kosovo Liberation Army are not new, namely, even during the war in Kosovo, when Richard Holbrooke was negotiating with Milosevic, Milosevic was accusing the Kosovo Liberation Army for war crimes, which means that Serbian state has had plans all the way from the beginning to try to set a narrative of the war in Kosovo. The accusations then were fueled in a decade later, after the publication of Carla Del Ponte's book, which sparked a whole international reaction to her allegations, which could have not been proven in the court of law. What's interesting in this period of time, there is another publication which has slipped through, so to speak, the tables of decision makers of the Council of Europe, and it's a book called Tell It to the World by a former assistant to the prosecutor in the ICTY. And the book speaks about the chain of command and the inability of the ICTY to put on trial the chain of command for the infamous case of this fridge in Peručac Lake. So what this gives us as a situation, as a contextual situation, is precisely the attempt of the international community to satisfy some sort of political force in setting up what is seen by many Kosovars as a tumor, kind of a cancerous kind of court in the justice system, which is probably very risky not to have it. And by having it, it cripples justice in Kosovo and it cripples the political system in Kosovo as well. One should also say that the allegations that have the allegations for which this court was set up were priorly investigated ever since the end of war. the office where I worked conducted these investigations. Little did we know at the time, as a local staff, we were not allowed to have access to such investigations, but a person named Jose Pablo Baraybar had conducted the investigations, and many people in the who were involved in looking into the ICTY documents know that already. So what is today, how is this today interpreted, is that many people in Kosovo remember a particular event in 2013 when a recording came up in the media of allegedly some Serbian Secret Service members trying to bribe a witness to testify of human organ harvesting. And that was published in the media, and that's how this debate sparked sort of in the Kosovar context. So the way this court is seen is there's a dystopic view of this court. Some people believe that this court will bring justice for the victims of the immediate aftermath of war in Kosovo, the political so-called political killings in Kosovo, and some people believe that it's a farce to satisfy the international community. And the dates kind of correspond because the President Taci was allegedly going to Washington to negotiate an agreement, and he had to return, and that was made public. So there is a degree of ambiguity. To add to this ambiguity, the specialist chambers are not transparent. The Kosovar public has very little access, even through journalists in the processes. It's very difficult for Kosovar journalists to go to Hague to follow the proceedings. It's very difficult for Kosovars to follow the court proceedings, etc. So this brings into the idea of transitional journalism and the difficulty of writing the first draft of history, so to speak, which goes back to the first point I made, the attempts of the Serbian regime, dare I say, to rewrite the narrative of war in Kosovo, to rewrite the narrative of the NATO intervention in Kosovo, by which particularly you can see the interpretation of Rečak, for example, by President Vučić of Serbia, and you can see the attempts for historic revisionism by the Serbian officials in all cases. Back to you, Luke.
Great, yeah, thank you for that, Abit. Yeah, that's really insightful. Xhorxhina, we'll come to you next. Are you able to tell us a little bit more about some of the cases? You know, where are we at with some of those cases, and perhaps some of those on the ground reactions that you're seeing in Kosovo?
Yes, thank you for inviting me. So as Luke explained, I am the correspondent for Balkan Insight for Kosovo, and we constantly follow and report on the special chambers. I have been reporting since late September 2020 when the first arrest happened. So the first one to be arrested was former Kosovo Liberation Army wartime commander. He was the commander of LAP operational zone, Salim Mustafa. He is known as Commander Tzali. His trial is also the first to have started in mid-September 2021, so almost 1 year after he was arrested, and he was in detention in The Hague. So he is charged of several. He has several charges, such as arbitrary detention, cruel treatment, murder, torture, that the prosecution claims happened between April and so sometime in March 1999. He continues to be in detention, and the court has not agreed to release him due to fear of risk of flight or witness tampering. And he is, similarly to the others, he has pled not guilty and has claimed that he was just fighting for his freedom with KLA. The prosecution so far has brought witnesses that have testified of brutal torture, beatings, And they have also used some photos from the time to connect what the witnesses are saying with the situation on the ground. They have used outfits of Mustafa and others to say that they are the people they claim to be. Another accused is Peter Shala, who is known as Commander Wolf, Commandant Uiko. He was the last one to be arrested from those that are currently in The Hague. So he was arrested in mid-April 2021. And he also has similar charges like detention, cruel treatment, murder, torture, and like this. So, but the indictment claims that this happened in June 1999 in Kukas in Albania, where the allegations were that the organ harvesting that was mentioned earlier happened, but the organ harvesting itself is not really part of the indictment so far, although it was the main point when the special chambers was established. Shala also has pleaded not guilty of all the charges. The special court so far has decided on only one case, which was not directly related to war crimes. It is the case of leaders of the KLA War Veterans Organization of Husni Kuchati and Asim Haradinaj. The verdict was given in sometime in late May 2022. And they were found guilty of obstruction of justice, intimidation, and unauthorized revealing of court documents. This happened after 3 batches of court documents were left at the Veterans Office here in Pristina, and they provided this to the media. And the court has decided that they have violated the law by doing so. Both of them, I mean, each has been sentenced with 4.5 years in prison and a fine of 100 euros. And one of the most outspoken cases, one of that has made the headlines all over the world, is that of former President Hashim Thaçi, former parliamentary speaker Kadri Veseli, and 2 other former guerrillas that were turned politicians, Jakub Krasniqi and Recep Selimi. They have a joint indictment of different war crimes and crimes against humanity that also include illegal detention, torture, murder, enforced disappearance, and sometimes between March 98 and September 99. All 4 of them have pled not guilty of all charges. And they have several times, the pretrial judge has decided not to grant release despite of the lawyer's requests. He has decided that they also have a risk of flight, can tamper with witnesses. They have also not allowed them to go to 3rd countries that are not disclosed to the public. As Abit said, the media is having some difficulties in reporting on the Kosovo Special Chambers because we are mainly following the cases online. And when they are offline behind doors, meetings within the court, we have no access to them, and it's often difficult to get in touch or in contact with the special prosecution or with the lawyers. I mean, we can do that via emails and phone calls, but still there are some difficulties there. So in the case of Thaçi and the 3 others, the special prosecutor's office, they increased the charges. So they put some additional charges in May, so they added more. They added some charges saying that they specifically mentioned a village in Kosovo's municipality of Suharega, so this village of Budakova, and they said that there happened some crimes were allegedly committed there, mainly the detention of 12 persons. However, people here in Kosovo have not really accepted the charges, Even the people from the village that was recently added to the indictment, even the people there have been very much angry with the indictment and with the special court, because it's mainly considered as if the special court is against the Kosovo Liberation Army, and as it is going against Kosovo's war to be liberated from Serbia. And one of the main points that is made to make this argument is this term that is used in the indictments. It is this term that says these former KLA members were members of a joint criminal enterprise. And this has been largely interpreted as if the joint criminal enterprise that they are talking about is KLA. So they are saying that, so people, media, legal experts, even the lawyers of the defendants have made this connection, since the indictment is saying that these people participated in a joint criminal enterprise. It means that the KLA itself was a criminal organization. However, the special prosecution and also some legal experts that work on such cases, they say that it's not necessarily the case. So a joint criminal enterprise doesn't necessarily mean that it's for the entire KLA, considering that not all KLA members have committed such crimes, considering that these people, that are indicted, that are charged for these war crimes, they were mainly on leading positions. So they were all commanders. They were all figures of authority. So the other interpretation is that the joint criminal enterprise in this case is for individual base. So how this is for the superiors and the orders that they have given and the crimes that they have committed. The court has also different, it has different issues as well. So on top of this generally not being welcomed here by Kosovo Albanians, it has some difficulty, for example, in compensating potential victims, because Kosovo's law on the specialist chambers does not have a specific criteria to decide in which circumstances the compensation can be awarded, which is very common for laws in Kosovo to have missing pieces of the puzzle, if I may say so, on how they should be implemented, how the articles of the law should then be enforced. And this is the case as well, which it has some difficulties. And also another one is directed to the prosecution mainly, because the lawyers constantly claim that the prosecution is not properly disclosing the evidence, especially when it comes to Albanian, because all of the accused are Albanians, and the evidence should be disclosed in their native language. And one of the main points is this, that they are not properly disclosing evidence. So this is what I have so far. So maybe we'll have questions.
Excellent. Yeah, thank you for that, Xhorxhina. So it sounds very much like there's some communication issues from the court itself there, which are some of the perhaps the key issues. Okay, great. Thank you very much for that. Finally, Gregory, thank you for joining us today. If you could tell us a little bit about your experiences with the court, perhaps some insight into your current strategy or concerns that you may have, that would be great.
Well, let us talk about the court and how the court started, and two prior speakers referred to this to some degree. But the court emanated from a report by a Swiss diplomat by the name of Dick Marty. Dick Marty was put on this case to investigate various allegations, not the least of which was organ trafficking that had been alleged in a book by the former prosecutor in the ICTY, Carla Del Ponte. That information that was given to him, the evidence that was given to him by the Serb War Crimes Office. There are a series of articles, debates on TV, etc., from the Serb ambassador who was there that will tell you about the 100+ pages that the Serb War Crimes Committee gave to Dick Marty, who apparently at that point had nothing. Since that time, there has been an array of information and a relationship between now the SPO, prior to the SPO, the Special Investigation Task Force, and Dick Marty and the Serb Intelligence and the War Crimes, the War Crimes Office. Suffice it to say that there are no allegations anywhere concerning organ trafficking. So if you go onto the KSC website and you look at the foundational documents, one of the foundational documents is the Marty report. And that outlines this organ trafficking allegation. Nothing about that anywhere, because nobody ascribed any significance or any evidence to that, and it's to prove it. That was the basis upon which this court started. That is the basis from which the Kosovo Parliament enacted this court to examine these items. So let us move forward with this. What has happened, and stop me at any time if you want to intercede, but let us move forward with how this case has moved throughout the Special Investigation Task Force and the now the SPO. Mind you, these events took place in 1998 and 1999 and were examined by all of these individuals for almost a decade. In the interim, what was going on was UX and UNMIC were in fact prosecuting cases in Pristina involving virtually all of the charges that are now set forth in this indictment. Most of those cases, I shouldn't say most, many of those cases were successfully prosecuted and many were not. They led to acquittals. But let us say that throughout all of that, none of the four individuals that you have before us in this indictment were involved. So let us move through procedurally how this is all transpired. As you noted, Mr. James, that just prior to the notification of this indictment, Mr. Thaci was scheduled to go to Washington and the White House and work on an détente, some kind of conciliatory meeting with the Serb government, and an unprecedented act that I certainly have never seen before, but I can be corrected. The prosecutor, without disclosing the indictment, publicly disclosed that President Thaci had been indicted. That meeting was tabled, and nothing remotely close to that type of political détente has ensued since then, and that was off the table. My client sat before the prosecutor, voluntarily came to The Hague for days and days of an interview with the office of the prosecutor, flew himself up and flew himself back at the behest of the prosecutor. Ultimately, when my client Mr. President Thaci was charged, he didn't remain in office as other leaders have done throughout the world when they were indicted. What did he do? He resigned his office and voluntarily came to The Hague. That was November of 2020. Since that time, he has been consistently denied pretrial release by both the pretrial judge and the appellate chamber. On several occasions, we have presented to the court a detailed explanation by the Kosovo police as to how the Kosovo police, who, by the way, given the KSC as a Kosovo court, works in tandem with the KSC. We set forth a list of procedures to ensure that no untoward conduct would be allowed to take place. That was rejected by the court. We have presented, as one of your speakers noted, assurances from third-party countries as to what they would do to ensure that no untoward conduct would take place while President Thaci was in their country. That was rejected. There are virtually no circumstances, none, after this man has presented himself to the court voluntarily, virtually no circumstances that this court is going to allow President Thaci or any other Kosovo Albanian to obtain pretrial release. Now, take that in parallel as to what happened at the International War Crimes Tribunal for the former Yugoslavia. Kosovo Albanians in the Haradinaj case and the Limaj case were indicted for many of the same acts that we have here. They were produced themselves voluntarily to the court, as President Thaci did. They were given pretrial release. They were allowed to go back to their homes while this case was pending. Again, there in the KSC, keep in mind that no Kosovo Albanian has been granted pretrial release. None. And what message does that send to the international community? What message does that send to the people of Kosovo? That nobody that comes before this court merits pretrial release. Now, let's move to the next step, which is the timing of this case. When this case, when the initial appearance took place and the initial conferences took place in the fall of 2020 on this case, the prosecutor stood before the pretrial judge and stated that this case would be prepared to go to trial in the spring of 2021. Let me say to you at this point, right now, the 7th of July of 2022, the prosecutor has not completed their required rule disclosures on evidence. 7th of July, 2022, they still have not completed it. And still our clients remain in custody. The problem, and we can allude to this in a variety of different ways, is the problem is, and I think Abit, you referred to this in some senses, this court it has no transparency and is not answerable to anybody or to anyone. It is a creature of the Kosovo parliament, yet it's not answerable to the Kosovo parliament. The ICTY and the ICTR, as you know, had to make regular presentations to the Security Council as to what the court was going to do. The ICC has to answer to the Assembly of States. This court answers to nobody. There is no one looking at this court to examine, in fact, what they do. The transparency that one of your speakers mentioned, concern, or the lack thereof, I should say, within the court, is something that is extant even with counsel. And why do I say that? Well, let's talk about the lack of disclosures, and it's not just the lack of evidence coming from the prosecution. It's the lack of exculpatory material when the prosecutor is attempting to keep our clients in jail, talking about the litany of evidence against them. They fail to turn over significant exculpatory evidence, undercutting their entire argument. So this moves on for a significant period of time. And I tell you folks, if you want to get an idea of what we as defense counsel are looking at, simply look at the redacted indictment that's on file with the court. If you look at that indictment, scores of names, addresses, places, and people have been redacted from the indictment, making it virtually impossible for counsel to figure out what's going on. One of your speakers just mentioned the most recent amendment in May. And the operative language that on this amendment, which was supposedly directed towards my client, was redacted. So you get an amended complaint on a redaction concerning your client, and the information is not there. That information, that redacted information, also applies to all of the witnesses, not all of them. So you know, well in excess of 60 witnesses have been redacted, whose identities have been disclosed, their names have been disclosed to defense counsel. We don't even have the ability to examine exactly what they're talking about. Scores of those witnesses won't be produced or identified until 30 days before trial. Others aren't going to be identified until 30 days before they testify. And still others, there are several of which the court has ordered that we're never going to find out who they are. That's exactly what we're dealing with here. We're dealing with a court a court system and a prosecutor's office that told this court they were going to trial in the spring of 2021. They haven't completed their disclosures now. They had no intention of going to trial during that time frame. They have consistently failed to timely turn over exculpatory evidence, and we have to deal with these redactions not only now but on the cusp of trial and during trial. If you don't think things could get worse, just recently they did. The court has ordered that for every interview of prosecution witnesses that the defense want to undertake, that the prosecution has to be involved, and we have to ask permission of the prosecution, and that witness has to be filmed by the office of the registrar. So let me give you a scenario. As you know, K4 had senior British military officers, among other officers, French, Americans, etc., that were there. Senior officers. So in order to talk to these senior officers right now, which the pretrial judge says that need to be monitored because of they don't want to relive the trauma of the trial itself, we have to turn to the prosecution. The prosecution is entitled to sets up this interview, and they're entitled to be there, and the registrar has to film it. And this order was just recent. Now, to add more absurdity to the situation, we have been talking to several international witnesses for some time. And I will tell you, these international witnesses who are on the prosecution's witness list haven't been contacted by the prosecutor in over 2 years. They don't even know that they're on the prosecution's witness list. So we have these witnesses, these international witnesses that don't know they're on the prosecution's witness list. And now we have to go through the office of the prosecutor to set up an interview with the distinguished diplomat who's been talking to us for some time. And that interview has to be filmed by the office of the registrar. I have been doing this type of work since the mid-90s, since I joined the ICTY. I have never ever seen the lack of transparency and the lack of fairness in a court as I've seen today in this court. We have reports back from diplomats, and I'll stop there in a second. We have reports back from diplomats where the president of the court, in conjunction with the prosecutor, have stood before the diplomatic corps in Pristina, telling these people how they're all going to be convicted and how my client Hashim Thachi is going to spend the rest of his life in jail. And as for any argument, Mr. James, to augment what one of your speakers said, that this is anything less than an indictment against the KLA, I invite anybody to examine paragraph 35 of the indictment. And paragraph 35 has a list of the people who are part of this joint criminal enterprise. And I suffice it to say, there is no person in the KLA who is not included in paragraph 35 and other people in the KLA. The prosecution may be uncomfortable with that, but is this an indictment of the KLA and all of the people involved in the KLA? There is no question about it. I could go on, Luke, but I don't want to take up all more of your time, but I welcome any question you might have on procedure, et cetera.
Absolutely. Thank you very much for that, Mr. Kehoe. We will now go to a sort of a round robin of questions amongst the panel, but I guess I have one straight away for yourself. You mentioned there about the accused not being able to be released. Xhorxhina said it's because there's a risk of fleeing or intimidation of witnesses. And you mentioned that much of the witness list has been redacted. Is that just simply because there is just too much of a large risk to them?
Well, I have a rhetorical response to that. Where is the president of a country going to flee to? He is he was the elected president of a country. Where is he possibly going to go to somehow flee the jurisdiction? No, this is a concerted effort to keep these individuals in jail. And let me give you an example of this. In one of our pretrial release motions that was denied by the pretrial chamber, it was appealed. And on the appeal, there were 3 judges, and there was an opinion that was written by one of the international judges, Judge Kai Ambos from Germany. And Judge Ambos said, well, you know, that keeping someone in custody is not the rule, it's the exception in international law. So if the defense comes up with a viable alternative to custody, that should be examined by the court. And that would include, among other things, third-party custody of President Hoxha or anyone else. On the next round of motions for pretrial release, the motion, of course, was denied by the pretrial judge. But when it went up to the appellate chamber, the president removed Judge Ambos from the panel and put another judge in, such that it was a 3-0 vote for non-disclosure. So the one judge that was on there, that to which we were writing what we were doing and what was plausible for release, was taken off the panel. You can go back to the actual docket itself and follow the orders through, but that's in fact what transpired.
Okay, thank you, Mr. Kehoe. Abit, Xhorxhina, I wonder if you have any questions at all, or maybe Mr. Kehoe, you have a question for one of the other panel.
I think they're very well versed, and they can ask me anything they want. So I don't have any questions off the top of my head, but I'll answer anything you folks want to throw my way.
Abit, yeah, I see your hand up. Please do feel free to jump in.
Yes, it's perhaps more of a political question, and I don't know if Mr. Kehoe can answer this, but looking at the history of creation of the specialist court, looking at the history of the resolution that led to Dick Marty's investigation, are we looking at something almost like a conspiracy to satisfy some political conglomerates within the international politics, or a side in the international politics, or a side of European Union that was all the way from the beginning, from the early 90s, looking at Kosovo as sort of something that could work to keep Yugoslavia together. If you look at the list of people who sponsored the resolution that led to Dick Marty's investigation, 80% of these people are today under sanctions by the EU and the United States, including the main guy there, the Kosachev. If you look at what is happening in Serbia with the missing persons, for example, and why there was never an investigation on the mass graves in Serbia, such investigation on existing mass graves in Serbia, are we looking at some sort of conspiracy? I know this is too far of a question, but I would be interested in your opinion.
Let me say at the outset that I spent almost 25 years in the United States government, and I've never been much of a conspiratorialist, because no conspiracy lasts very long in the government setting. But that being said, just dealing from the basis of fairness of it, I mean, all I think that my client and the rest of these individuals are looking for is an element of fairness. But if we examine exactly what has transpired, and this is of recent vintage, Dick Marty was the gentleman who was responsible for starting at least the investigation that led to this court. Our clients were arrested in November of 2020. shortly after their arrest and taken into custody, an assassination attempt was hatched by the Serb intelligence services using black ops to do it, to assassinate Ambassador Marty and then blame the Kosovo Albanians. Now, this is not something that comes from Greg Kehoe. This comes from the mouth of Dick Marty in the last several months, as well as Swiss intelligence, who uncovered this conspiracy. And to this date, from what I understand, Ambassador Marty, while his identity wasn't changed, is under level 4 protection 24 hours a day. Now, it's difficult to make this stuff up, but this is exactly what's transpired in the last several months concerning what Serb intelligence is willing to do to ensure that things go their way in this court. Now, I don't know about any of the other players, Abit, but I do know that that has transpired, and I do know there are various other elements in other cases where Serb intelligence has doctored evidence and restructured evidence, and much of that evidence is being given and has been given to the SPO.
Cool. Okay. Thank you very much for that. I guess I have a question for you, Xhorxhina, actually. So we spoke a little bit there about it being difficult for reporters to get access to what is happening in the court. If you were to propose a recommendation on how to fix something like that, what would you do? How would you try to improve that?
Thank you for the question. So one of the main problems, I think, is when the court goes, has these sessions, behind door sessions, and of course they will not be published. So they will not be part of the live. I mean, it's not live because it's some minutes late. It's like 30 to 40 minutes late, the publication of the court session. So in that case, of course, it won't be made public for everyone, but even us that are reporting and are constantly following it, we don't have access to what is happening. And I think it would be helpful to at least have some information on what is going on, because if it is in these cases, in the court cases that happen on the ground, that we are there. For example, I also follow other big court cases here in Kosovo, and I am physically there while the session is happening. And even if it is not open for the public, we as media are allowed or not allowed to publish some information that the court decides us. So it's very clear. The court makes very clear what we can and cannot publish. And if some media publishes something that the court doesn't allow, then there are punishments for that. But not being able to know what actually is happening also in those cases, it's very difficult for us to report as well. So that is one thing that I think must be changed.
Thank you, Xhorxhina. Yeah, there's a question. There's a couple of questions in the Q&A, and we'll get to them now. And one of them is quite similar to that, and I'll read it verbatim. We've heard about the lack of transparency and the lack of oversight by states, but in fact, the US and the EU are major funders of the court. And in case of the EU, it is directly the Commission and External Action Service in charge of overlooking the court. While this might not be ideal in terms of public transparency, there have been reports of corruption of local investigations, including by the EU mission there. Given the danger the victims and the witnesses are facing, what would be the level of transparency in the proceedings that the speakers would welcome? And I think that's an open question there. So to rephrase that question, how would you increase the transparency of the court there? Xhorxhina, you've given us one example. I wonder if anyone else in the court can in the presentation can add to that.
Well, like, I mean, the first way to limit the transparency, or to get, make it more transparent, is to do the things that your prior speaker was saying. Make these proceedings open. That doesn't mean that people that require protective measures while they're testifying should not get protective measures. That goes without saying. But the level of secrecy and behind closed doors operations that go on here, I've just never seen before. So, if you want transparency, then you should be transparent. You know, when I was in Iraq and advising the folks in Iraq about transparency, I had grown up in the ICTY system. And I said, if you want to show people that you have what's going on in the courtroom, film it. Let people that are in the barbershops and the package stores see what's going on in your courts, and let them make a decision for themselves. Here, the lack of transparency is simply overwhelming. And if you just, again, want a small example of that, just look at the indictment and look how much is redacted and look how much is not there. That is what we have to address. And while we might get some of this information come 30 days before trial, there's no guarantee that we will get all of it. And then once you get that information, how do you begin to investigate? So is this a level playing field where the presumption of innocence is being honored? I'll let you answer that for yourself.
Thank you. Cheers. Abit, did you want to chip in on that one at all, or should we move on to some of the other questions?
I have nothing to add to that, actually. I completely agree with that.
Excellent. Okay, great. So there's a few more questions. I'm going to ask one now, though. So it ties into, Mr. Kehoe, you said that no organization has an oversight of the court itself. UNMIC, they do I think it's a bi-yearly report. And I think recently at the end of their report, they started attaching an annex at the end about the court's update and what the court has been up to in that reporting period. I wonder if UNMIC would be a suitable vehicle for that sort of reporting on the court itself.
Well, UNMIC and the UN, UNMIC, of course, is a UN arm of the UN. They don't have any jurisdiction. This is a Kosovo court. This is a court that has been established under the Kosovo Constitution. So UNMIC simply has no jurisdiction to do that. Now, should something be employed that the European Parliament or some other investigative body should be looking at what this court is doing? Absolutely.
Great, thank you. And there's a couple of questions here, which I think both can be tied together. One is from one of our researchers here at the platform, Luke Rue. He asked, what is the perception of the court amongst Kosovars? Is there public polling on this? And do different ethnic or linguistic groups have different perceptions to the court itself? Now, tied to that question is a question from Madeleine Moose. Why, who do you feel the special court is for? Who is it for? What is the true purpose of the court?
So if I may, sorry.
You go ahead, Xhorxhina.
Thank you. So about, I cannot comment on Madeleine's question. I apologize, but I cannot comment on who I feel the special court is for, since I am reporting on the court. So that would be a conflict of interest on my part. But on the perception of the court, as I mentioned, among Kosovo Albanians, the court is resented. So it's not really welcomed as a Kosovo court, as it was mentioned. This is a hybrid court, so it is part of Kosovo's judicial system, but it has a almost completely international staff. So it has also non-internationals, but it is not welcomed as a Kosovo court. It is considered as something from the outside coming in against Kosovo and Kosovo Liberation Army. So it's mainly considered as it is a court that will throw shade on Kosovo's war for liberation against Serbs. Among Serbs, then the perception is not that negative. It is more welcomed. It is considered that they will get some justice on what allegedly the KLA members have done, considering that Serbia doesn't accept as a liberation war and considers it as a terrorist organization, actually. So yeah, there is a difference among different ethnic groups, so a difference between Albanians' perceptions and the Serbs' perceptions of the court.
about a year and a half, about 2 years ago, I've conducted some 12 focus groups with people with direct experience in conflict and indirect experience in conflict in Kosovo, including a focus group in the northern part of Kosovo. And in all focus groups, the court, one of the questions was, how do we deal with troubled past, with historic revisionism and truth commissions, and how all these questions were discussed. And none of the focus groups see the court as setting justice for the victims. There was focus groups in the regions where there was victims or killed people after the war as well. And I was very surprised that both Serbs and Kosovo Albanians see the court as some sort of political chameleon, some sort of justice chameleon. It's a political instrument that is there to satisfy someone. And that someone, that's why I'm hesitating to call it conspiracy, obviously. I'm not a conspiracy guy as well, Greg. But I have to question everything. If you make the connections, I'm a journalist lecturer. For me, the why, the how, the fundamental 5 questions are the constitution of what I do. And if we answer all these questions to the bottom, we'll see that there is a lot of dust in the air about the court. And that's how the people feel, actually. There's a difference in age groups and in experiences. People with indirect experience in conflict are far more prone to sort of refuse collaboration or coexistence or anything. People with direct experience, such as myself, are a little bit more open to collaboration with Serbs and with dealing with troubled past, finding the truth, etc. But what these two groups agree on is that the court is a political instrument to satisfy some political interest. And I was very surprised by this result, to be honest. We're publishing work in the next coming months, etc., on historic revisionism. The court is also trying to do this historic revisionism, or from the Serbian side, setting the record straight. The expectation from the Serbian community is that the court will say that Račak was fake, Izbica didn't happen, the Rezala was all killed, the victims in Rezala were all killed by the Kosovo Liberation Army, etc. But by all means, this has the court has not been able to provide that message that it's about the specific cases because of this lack of transparency and because of this secrecy almost. We don't know why these people are being accused and in which cases and for what. Joint criminal enterprise is such an ambiguous term. It's in the UNEs, in the UN language, it's such a comprehensive term. It's everything and nothing. It means nothing. It means everything. So it's very, very ambiguous from the perception side, or at least that's what people feel like.
If I can just add to that, and well, very well said, Abit. I mean, it is especially a description of a joint criminal enterprise. I think the question has to be asked by this group and anyone else's: why have no Serbs been charged in this court? There have been none. This has been under investigation for heaven knows how long between the Special Investigation Task Force and then the SPO. And all of the people that have been charged have been Kosovo Albanians, no Serbs. And we all know that horrific crimes were committed by Serb forces, the Serb police, the Serb paramilitaries, yet no one has been indicted or charged. And the question, why?
Xhorxhina, I see you've got your hand up there. Did you want to come back to that?
Yes, I just wanted to add that this is a very important point because among the perceptions of the court, one of the main points is that it is considered to be an ethnic court. So it is considered to be biased and against one ethnic group and not the other. So as it was mentioned, because all of the accused so far are Kosovo Albanians. Among Kosovo Albanians especially, it is believed that this court is there just to indict Albanians and to go against the KLA and their war, and not against the war crimes that were committed by the other side, by the Serbs. That was all that I wanted to add.
Thanks, Xhorxhina. Okay, so we did say that this webinar would be maximum 1 hour. We have hit 8 p.m. Here in Central Europe. There are a couple more questions. I'm just going to ask the panelists, are you okay with answering just a couple more questions before we finish?
Of course.
Great, absolutely okay. So we'll go to the very first question that came to us earlier, slightly different to what we've been speaking about so far. From Biza Ismaili. I believe 2 standing questions of concern for everyone in Kosovo today are: 1, who oversees the special chambers in terms of human rights and other violations, knowing who has sponsored the resolution that led to its establishment? And 2, in spite of full cooperation by Kosovo institutions with international justice and special chambers, why do they lack trust in Kosovo institutions for guarantees to have the defendants released pre-trial? And that can be to anyone.
Well, if I had the answer to that second question, I would take it to court, and maybe we would have some productivity in the release of the clients. It's a mystery to me. It's a complete mystery to me, other than that this court has decided that no, and let me repeat, no Kosovo Albanians will be released. That's the only thing that you can infer from this. Were there some witness tamperings or some threats to witnesses, I am sure we would have heard about that since November of 2020, and we have heard nothing about that. So I go back to what I said before. It appears that a decision has been made that no one's going to be released, and that is that. And no matter what we write or what explanations we give, it falls on deaf ears. And if we do happen to get a sympathetic ear, that sympathetic ear is removed from the chamber.
Yeah, some very pointed question has just come in, which ties into this as well. Why would a Western-backed court actively target Albanian ethnic people who are the more pro-Western group rather than the Serbs? Perhaps Abit, you might want to maybe jump in on that. I think that ties into generally what we've been speaking about over the last 10 minutes or so. What is that conspiracy, I suppose?
Well, I mean, my interpretation is that there has to be some sort of, because in some sort of balancing, and I can't explain this. If you speak to many people back in Kosovo and in Serbia and in the region as well, is that the opinion is that there was a lot of Serbs indicted by the ICTY, and I cannot comprehend this because Serbia has gone to war with Bosnia, Serbia has gone to war in Kosovo as well, and obviously there will be more people indicted in Serbia. And but to tie into this question is that I don't think courts work with the way a nation is pro-Western or non or against Western or on the basis of ethnicity. But this court seems to work on the basis of an ethnic group. So I will not add more because I think Gregory already spoke a lot, but I would like to use the chance that you gave me the word to just re-ask a question that is coming in the public, and I'm very, very intrigued by the fact that the prosecution office have hidden information from the defense counsels, and what are the consequences of that? I've been following the court, and I know probably Gregory has something to say about that, but what are the legal consequences of that when the prosecutor hides information from the defense?
I have brought this up several times, Abit, and I have brought up and brought to bear the convoluted explanations that the prosecutor has given for the lack of disclosure, which candidly don't bear scrutiny when you examine them, certainly the timing of them, and I'm glad to go through them. But what has happened when it's been presented to the court? Nothing. What happens when a date is being ordered for disclosures by the SPO and they don't meet that date? What are the ramifications? Nothing. What happens when they're told to file something by a certain date and they unilaterally decide to file it after that? What are the ramifications? Nothing. So unfortunately, this is the first court I've ever been in where an entity, a party has consistently transgressed and there have been no ramifications. And there have been none. And I think that the court record and the docket bears that out.
Thank you very much, Mr. Kehoe. That kind of answers one of the other questions by Kustrim. I hope that answers that for you. Yeah, so there's one last question, I think. I mean, this is probably going to be again to yourself as well. Do you think that the trial is not starting because the SPO just simply does not have enough solid evidence against Mr. Faci?
In part, of course. I think that when they said that they were in November of 2020, when they said that they were ready to go to trial in the spring of 2021, and they have amended the indictment several times and didn't have yet to finish their disclosure, I hand the question back to you. What is one to think? What is one to think that they took all of this time to disclose information that they supposedly were ready to move forward with in the early part of 2021, yet to date they haven't complied with? Of course they weren't ready to do this. And any argument to the court that they were ready to go to trial in the spring of 2021 was specious.
Yeah, there's definitely one left, I think, for the audience to think about rhetorically. Xhorxhina, I saw you've got your hand up there. We'll give yourself and Abit sort of one more response, and then we'll call it an evening at that.
Yes, one final thing that I wanted to add for the previous question is that the court, when it was established to investigate and then potentially charge former KLA members, because it was considered that Kosovo failed to do such thing. It was this perception that Serbia had its war crime trials and Kosovo didn't do the same. So when it was signed at first by former President Atifete Yayaga and also Hashim Thaci, who then was, I think, Minister of Foreign Affairs, if I'm not mistaken, that was basically the idea, the reason that it started. So that's all. Thank you.
Abit, any final words from you at all?
No, I'm just going to wrap up with what I said, that the court actually makes it a lot more difficult for Kosovo to move on and sort of move through the transition for the people of Kosovo, for the institutions, and certainly for the justice system generally. The UN has created a very weak justice system in Kosovo by installing former judges who worked in former Yugoslavia, by only employing people who were experienced judges in former Yugoslavia. On top of that, there was a number of cases where judges serving only 6 months have prosecuted people, and then they went back to their countries of origin, and then cases were taken over, and there was a lot of sloppy work with war crimes prosecutions in Kosovo. And on top of this, now we have a tumor of a court, an anomaly of a court in the justice system in Kosovo, which makes it very difficult for Kosovo to deal with this troubled past. It contributes to more ambiguity in these court-based truths and narratives of war. It adds a lot of dust in the air, so to speak, and it will be very difficult for Kosovo to sort of deal with this as well, on top of everything else.
Thank you, Abit. Okay, that is all of it from me. I guess one last question to Mr. Kehoe, whilst I have you here. Is it legally possible for Kosovo to repeal the court and remove it from its constitution?
Well, I mean, I don't pretend to be a lawyer that is well versed in the legal system in Kosovo. I suppose theoretically anything like that could happen, but I think it would be a difficult thing to do. So I will plead partial ignorance and partial doubt that it will ever come forward.
Okay. Any significant developments in the next 6 months, do you think?
Well, we have a status conference next Wednesday. Stay tuned.
Okay. All right. Thank you, everyone. Thank you for the panelists, Xhorxhina, Abit, Gregory. Thank you very much for joining us this evening. We have gone over time, but I hope it's been of interest and use to everyone who has tuned in to listen to this. This will be chopped up and put up as a podcast in the next week or so. So keep your ears out for that. Thank you everyone for joining us. And we will maybe plan to do another webinar on the court in 6 months' time. We'll see what happens then. Great. Thanks a lot, everyone.
Thank you.
Thank you.
Bye-bye.
Bye-bye.
Bye-bye.